Can I welcome members to the 52nd meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are on airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed the oral evidence session with Professor Kevin Brown on the repeal of vagrancy will be recorded by Hansard? Can I seek the agreement of the meeting for that? Agreed?
Agreed.
Okay, thank you. Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matter under consideration? Any members who have interest to declare in relation to today's business should do so or when the particular matter arises. Okay. Can I ask members whether they have any interest to declare at this stage? Okay, none at this stage. Just remind members that they can do it through the agenda. Agenda item number 1 is apologies. We have apologies from Connie. Any other apologies? No, we're all on. Can I advise members that committee members Danny Becker, Doug Beattie, Morris Bradley and Deirdre Hargey are attending the meeting virtually? Agenda number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 16th of October 2025 are pages 5 to 15 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 16th of October 2025? And if so, I will sign the minutes. Are anybody any problems with the minutes? No? Then I will sign. Agenda item number 3 then is matters arising. 3.1 update on meeting with the Justice Minister on the 20th of October 2025. Can I remind members that myself and the Deputy Chairperson Deirdre Hargey held an informal meeting with the Justice Minister on Monday afternoon. Can I refer members to pages 3 to 4 of the table pack, which is a draft note of the informal meeting? Set out in the note, the 2 key areas discussed were the Enabling Access to Justice programme and then taxation in particular and the PACE codes. There is a word to be added in. We'd like to add in strip regarding strip search, which I think is in page 3, if I'm right. Are members content then with that? Any questions arising out of that table? No. Just for accuracy, I'm trying to find the actual. Yeah, so it's page 4. It's page 4 of the table pack, and it's the PACE codes element, and it's the 3rd paragraph down. So instead of for a person arrested who may be searched, that will read for a person arrested who may be strip searched, which is a big difference, of course. Okay. Members content with that then? The Minister has indicated her intention to bring forward a further amendment at consideration of the Justice Bill, which will allow the Department to proceed more quickly with taxation reform than had been planned. One of the reasons for this is an increase in fees by the taxing master, which has added 7 million to the legal aid budget, which the Minister advises is not sustainable. Can I remind members that the committee is scheduled to receive oral evidence from the Department on the Enabling Access to Justice programme on the 20th of November and will be provided with more details on the issues and delivery plan at that time. So are members then content, or if they have any other queries about the note of that meeting, and then also any other issues? No, you're okay. Next item is 3.2, which is in matters arising, media and family court pilot. And I refer members to the invitation from the Lady Chief Justice's Office to an informal information session with the judge regarding the media in family court pilot, which is at page 5 of the tables pack. The session will be held in the Upper Bar Library. It's on 3rd of November at 4 p.m. 3rd of November is a Monday. Can I ask members then to advise the clerk if they plan to attend the session? Can I ask members if they have any other matters arising from the minutes that they wish to raise at this stage? No? Okay. Agenda item number 4 then is the Justice Bill Repeal of Vagrancy. Professor Kevin Brown, School of Law, Queen's University, Belfast, oral evidence. Can I refer members to pages 17 to 52 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence on the Justice Bill from Professor Kevin Brown from the School of Law at Queen's. I would just like to welcome Professor Brown to the meeting. You're very welcome here, Professor. And get settled by all means, and then make an opening statement if you would, please. Thank you.
Okay. Thank you, Chair, and thank you to the committee for inviting me to give evidence today. I thought it might be helpful if I began by setting the scene with a short 5-minute overview of what I see are the key issues and possible ways forward, maybe to help engender some discussion and debate. I want to start by saying that I personally fully support the repeal of Section 4 of the Vagrancy Act 1824 and the Vagrancy Ireland Act 1847. They are deeply outdated laws rooted in a 19th century mindset that treated poverty itself as criminal. Indeed, if you look at the year of the Second Act, 1847, it was passed during the ongoing suffering from the Great Famine. The provisions still in force that are relevant to homelessness today are Section 3 of the 1847 Act, which criminalises begging, and Section 4 of the 1824 Act, which criminalises rough sleeping. Together, they treat poverty as a threat to public order. Section 4 criminalises the homeless person. Section 3 criminalises the destitute person who asks for help. Both are crimes of status, and that was often how the Vagrancy Acts worked over the centuries. They punish existence rather than conduct, and that's not how the modern criminal law works. A complete ban on begging is actually a crime of status because it criminalises destitution itself. And in the modern criminal law, we draw a clear line between status and conduct. Rough sleeping is purely a status offence. It punishes a person for being without shelter. That's arguably indefensible in modern criminal law or human rights terms. Begging, by contrast, is conduct. It isn't intrinsically wrong. It's not what I'm saying. In most cases, it's passive and harmless. But in a small number of cases, it becomes aggressive, intimidating, obstructive, or exploitive. And in those limited categories is where proportionate legal tools, I believe, are justified. Therefore, while I very much welcome the Department's recognition that the Vagrancy Act provisions are outdated and in need of repeal, I would caution that repealing without replacement in relation to begging, would potentially create significant operational gaps. I believe that existing public order and anti-trafficking laws that are mentioned by the Department of Justice in their consultation, and indeed the response to the consultation, are not well suited to filling that gap. They either leave a gap in the sense that harmful behaviour is not criminalised, or they over-criminalise by treating vulnerable people as public order offenders. And that's why myself and some of the other responses to the consultation argued for narrow purpose-built provisions. They target harmful behaviour without stigmatising poverty. At present, in relation to begging, the PSNI operate a proportionate engagement first approach. Officers engage with the person, establish the circumstances, offer support and signposting. There's a lot of joined up multi-agency working, and ask them to move on. If that doesn't work, according to the Department of Justice and the PSNI, they can issue out-of-court disposals such as community resolution notices, and only in persistent or aggressive cases do they move to arrest. Arrest is seen as a last resort by the PSNI. If the begging offence disappears without anything in its place, I fear it takes the feet out from under that approach, that graduated proportionate approach. The police would lose the current structured approach, which involves, as I say, engagement, warning to a disposal, usually community resolution, then only prosecution where necessary. So without a statutory basis, this, as I say, is in relation to begging, not rough sleeping, they would either have to ignore genuine concerns or rely on much blunter public order offences. So you can see it potentially negatively affects in both directions. One that leaves behaviour that is harmful. There's a gap in the law, but it potentially leads to vulnerable people being subject to more severe public order offences as well. So it works in both directions. I would also be cautious about other unintended consequences, and it wasn't one that I have to admit that I picked up on myself, but it was in reading the legislation in England and Wales that's come out from the Labour government, and also then looking at the legislation from the Republic of Ireland, because this legislation, unusually for legislation that we're dealing with, predates partition, so it applied both north and south. And both of those jurisdictions are legislating. Obviously, the Republic repealed its vagrancy provisions some time ago, a few decades ago. England and Wales is in the process of doing so. But not only have they responded differently in terms of begging than is being proposed in Northern Ireland, but they also identified a gap in relation to trespass with intent. Now, as I said, I've noticed that provision in the English and Welsh legislation and indeed the Republic of Ireland. I'm not sure whether that provision has become obsolete, and it's not about homelessness. It's just the way Section 4 was written and the way statutes were written at the time. They often were they listed a whole range of behaviours. And if you look at Section 4, it includes like fortune telling and things like this, as well as that. So I think the evidence base is thin, but I think the trespass with intent is another example of why we need not to be basing it on assumptions of what works, and looking, as the committee is doing, and I think it's really useful what the committee is doing to avoid creating avoidable gaps. So I suppose the position that I take, and really it's just outlining it to hopefully engender debate and to take questions. You might have obviously your own views as to what the way forward should be, but I would recommend, if it was me, would be repealing the rough sleeping offence and not replacing it with anything, because it criminalises the person's status rather than their conduct. I would repeal the Vagrancy Ireland Act 1847, Section 3 in relation to begging, but replace it with a narrowly drawn offence of arranging or facilitating begging for gain. That's what's going through in England and Wales at the minute. A very similar offence was passed in Dublin as well, but whenever they had repealed their vagrancy provisions. So that offence does not target individuals who are begging. That's those who are exploiting the vulnerability by arranging or facilitating begging for gain, so not the individuals who beg. And then rather than, in relation to difficult individuals' acts of begging, I don't think there's need for a new offence per se, but a proportionate desist and move on direction for the PSNI. And that would be set out confined to genuinely aggressive or obstructive or intimidating cases of begging. This is the approach that the previous government in England and Wales was partly going down, but it was was creating a very detailed, some say overly complex system, which has now been abandoned. But one of the provisions was in relation to a move on direction. It's also the approach that the government in Dublin adopted whenever they replaced the legislation. I think that would offer a more balanced approach rather than just creating another begging offence that would only be an offence if someone was to ignore the move on direction. And then, as I said, I would suggest not necessarily that we need a new trespass with intent offence, but maybe the committee would have a further look at that, speak to the PSNI about, is it being used? I found reference to it in Freedom of Information from the request from the Public Prosecution Service and a statistical release from the Policing Board, but I couldn't see whether it's still being used in Northern Ireland or not, but something maybe to be worth looking at. And I would hope then its approach like that could decriminalise poverty while preserving a proportionate response that addresses genuine harm. So I'll say thank you at this stage and look forward to discussing these issues with you and addressing the questions you might have.
Thank you, Professor Kevin Brown. Thank you very much for that presentation and all your work, your diligent work within your submissions to the consultation. I'm going to put out to members. Brian is first on the list.
Okay. Thank you, Chair. Thank you, Kevin, for your paper and for your research and suggestions on this matter. Certainly, I mean, I understand what you're saying, that vagrancy, rough sleeping should not automatically be an offence. I'm also mindful, I attended this week a meeting in Belfast City Centre with various businesses and other elected representatives and the police regarding ongoing incidents in Belfast City Centre. And I do think I, as a Belfast elected representative, and all of us as elected reps, do have to protect our public spaces. I do think rough sleeping should be absolutely discouraged. People should not be sleeping on the street. I understand the view that you can't just arrest your way out of the problem, but I do think there needs to be legislation which discourages it and gives the police the tools that they need to discourage it. So I would be concerned that we leave the police with insufficient tools, and that was highlighted. I mean, this was brought to light by a recent brawl, which you might be aware of, in the city centre, yes, which occurred, and the police said, yes, there is a problem with people with complex needs and addiction issues, mental health issues. They're a harm to themselves, they're a harm to each other, but they're also a harm to the general public. And again, if that is discouraging people from going into the city centre, then that is something that legislation needs to help prevent. So that is my concern. The police highlighted to us some additional powers that the police in GB have: public space protection orders. I don't know if you're familiar with that. Yes. One, dispersal orders, civil injunctions for antisocial behaviour. So it's just to know that they have a range of tools that they can bring to bear, not automatically just going for one, but looking at there is harassment that is happening of people, and I hear that from people within the city centre. And when businesses who are trying to survive financially are having to clear up every morning human waste and remnants of people rough sleeping, to say that we don't have a view on that is insufficient. I think our view should be absolutely people should not be rough sleeping, and not rough sleeping in our commercial centres. So it's I know you've highlighted, but that's my concern, that we give the police and the authorities sufficient tools, not just to work with people and try and encourage them not to be doing this, but also that there is the tools for enforcement when required.
Yes, I think, and I think that's from reading the responses to the consultation, I think that comes through from the PSNI's response, and also I think there was 2 responses from representatives of businesses in Belfast. And I think that is also, you can see the concern that's expressed there. For me, I looking at obviously there's the two provisions. There's the one in relation to begging, and there's the one in relation to rough sleeping. And the reason that I draw the distinction is because the rough sleeping is more of a conduct. Is a status, whereas begging is conduct. But in terms to address the point on rough sleeping, in terms of people sleeping in doorways, for example, I'm guessing looking at the issue, if someone, when the business opened, refused to move, it may well be a health-related issue that they're not moving. That could be physical or it could be mental health issues, and that would need to be addressed by the emergency services, which might include the paramedics and the PSNI attending. There is currently under our public order legislation an obstruction offence as well, if they were obstructing the public pathway or roadway, and potentially that could be, you could see that could be used by the PSNI. Also, having looked at some of the evidence, again, why someone who's rough sleeping might be refusing to move, or assuming that it's not health related, it could be that they are intoxicated. Obviously, there's a relationship between rough sleeping and drug and alcohol addiction. If it is that it's not so much a serious health-related issue, but that they were drunk in a public place, I think that's Article 10(1) of the 1980 Act. So they could be arrested under that provision as well. And then where it spills into fighting and other very obviously disorderly behaviour, there's I think Article 19 under the Public Order Act would apply as well. So and I think the relationship between, and I was interested in looking at the responses to the consultation and some of the documents you've received from on this matter as a committee. And sometimes there's not from everyone who's participated, but sometimes you can get a conflation between homelessness, rough sleeping, and begging, and people talk about we need to decriminalise homelessness. What exactly does that mean when they say that? Do they mean in rough sleeping and begging? Do they mean begging in all circumstances, and so we have no begging offence, or because it's kind of a catchy phrase and one that tugs at the heartstrings, because we don't want to be criminalising people who are obviously who are homeless from a moral standpoint, never mind a human rights standpoint. But having looked at what the proposals in England and Wales under the previous Conservative government, because they legislated for repeal of their vagrancy provisions, and in rough sleeping it's the same provisions, obviously different in relation to begging. It was a specific act for pre-partition Ireland, but they created a nuisance begging provision, and they also created a nuisance rough sleeping provision. And it was the nuisance rough sleeping provision that I think outraged a lot of people, in particular, that they felt that was criminalising homelessness. The nuisance begging provision, I don't think, was as controversial. Now, all those provisions, as I said, there was about 30 clauses in that bill. It was a very complex bill. I think that was the one on nuisance rough sleeping was the one that caused a lot of issues. In relation to, I suppose, if someone was consistently rough sleeping and refusing to move and causing a lot of issues, I suppose there's also, if there's talking about persistent, there are ASBOs that still exist, and that's partly me with another hat on, and that I chaired for the DOJ, all the groups that came together to look at reforming the ASBO, and I think potential, I don't want to get bogged down in that now, but potential reforms to the ASBO would help to address those issues as well, if there was a case that someone was persistently doing that.
Mm-hmm. Yeah, I mean, that would just be my concern, that we repeal this vagrancy, rough sleeping, and we're actually making it difficult, especially for businesses, and people going about their own peaceful lifestyle to go in, to be in the city centre and find that we're, as I say, making it more difficult for them to address the negative consequences of people who are causing nuisance. And whilst we have sympathy for people with complex issues in their lives, where that is causing real difficulties for businesses and people just wanting to pass through the city centre, then we have a duty to ensure that the police can act and the authorities can act.
I understand, and I'm thinking you're North Belfast, isn't that
yes,
right? Yes,
that's
so
right.
You're one of my MLAs, and I pass through the city centre every day, going to Queens from north to south. Mm-hmm. And where there's difficult behaviour that I would see, it would tend to be in relation to begging, which has become aggressive or intimidating. Mm-hmm. I don't tend to see, and I might have missed it, but I do pass right through Royal Avenue and up Dublin Road, etc. That it's in relation to begging, where it can spill into what's harmful and intimidating
and harassment of people.
And harassment of people.
Yeah. Okay. Thank you, Chair.
Patsy?
Yeah. Thanks very much, Professor Brown. And thank you for making the point which I was going to make anyway. You don't want to criminalise either ethically, morally, legally, or any other grounds homelessness. You just want to go. You don't want to go there. Could I ask just in regard to some of the documentation that you've referred to there about the repeal of vagrancy and the rights of vulnerable individuals and the issues around reform of what we have in front of us. You state that it must be implemented carefully to avoid creating unintended legislative gaps. Now, you've touched on some of that there, but could you give us, if you like, the specific bullet points of what those unintended legislative gaps might be? And then, likewise, in a similar type vein, maybe related or the same issue, the same policy thrust anyway, to ensure the well-intentioned repeal of vagrancy provisions does not inadvertently create new challenges for individuals and communities alike. I'm sure there's an overlap there between the legislative gaps and the challenges that they would create for individuals and communities alike. Could you give us a wee bit of an insight to those challenges and likewise then to the voids that might be there legislatively, and sort of in bullet point form, if you could, please?
Certainly. In relation to the begging provisions in particular, I think that's where the legislative gap is likely to be. In relation to the European Court of Human Rights, we won't get bogged down in the jurisprudence there, but they had a case in 2021 that said an absolute prohibition on begging is contrary to Article 8, but then they revisited through another case a year later and said that if there's targeted provisions that don't have an absolute prohibition on begging, that they are not contrary to the European Convention of Human Rights. I believe that was a Danish
specifically
case.
Sorry for interrupting, but what did they mean by targeted provisions? Do you know just...
So if you said, so currently what we say is under the vagrancy provision, begging is a criminal offence. So in all circumstances, not that the PSNI arrest people in all circumstances who are begging, but the law, that's how the law is interpreted, that it can apply in all circumstances. Most countries now, if they do have offences in relation to begging, will say that if it's aggressive or it's harassing or it's obstructive, then it becomes a criminal offence. And that's what the European Court was saying. Those kind of measures are proportionate and so are not contrary to the European Convention, whereas a complete prohibition on begging, which we currently have from the pre-partition legislation, that is contrary to the European Convention of Human Rights. And in terms of what those gaps are, is a gap that was identified in both in London and in Dublin. Said Dublin was some time ago, but they said that those who are organising individuals to beg and exploiting individuals in potentially through gangs, for example, they should face prosecution for doing so. So there's an offence going through in Westminster at the minute, and one already in operation in the Republic of Ireland. The response, I think, of the DOJ on that was to say I don't want to misrepresent it, but I think they said they didn't think it was an issue in Northern Ireland at the minute, and if it became an issue in Northern Ireland, they could potentially go and look at it. Some of the responses to the consultation suggested that people did think it was an issue, and people organising it, and people to beg not in all circumstances or taking advantage of people. And so the DOJ said, well, even if that is happening, you could use the human trafficking provisions, but without getting too technically bogged down and all that, it sets understandably a very high threshold for human trafficking provisions. It doesn't always have to be people who are brought in from another country, but it's a high threshold of coercion. And so I think the DOJ is leaving exposed the issue of people being people facilitating or organising people, often people who are vulnerable, into begging, and often taking most of their proceeds. So that would be an area where I think there clearly is a gap. Another response to the consultation suggests that, well, you could just wait and see if it becomes a problem, but I'm a bit worried that the speed of things naturally takes time for legislation to be passed, and do we want to leave that, and do we want to communicate to wider society and to gangs that we've decided not to legislate on this? I think that's worrying, and then the other issue is where individual instances of begging itself become intimidating or harassing or obstructive in shop doorways, for example, you mentioned. Then I think there should be a provision there that allows the PSNI, so it should be legislated for, to request that someone desists or instructs, gives a direction to someone to desist and to move on. And it's not a crime in itself, so they haven't been given a criminal record. But the PSNI would tell them and say, if you do not desist and move on, it's a criminal offence. That was something, again, they have that in the Republic of Ireland, and again, through the PSPO legislation in England and Wales, they effectively have it, even if it's not there at a national level. So a desist and move on direction, because otherwise I think the PSNI might feel either they're going to have to say, well, begging is no longer anything to do with us, and we know that the PSNI are under immense pressures in terms of resources, and do we want, in the city centre there's been a lot of discussion in Belfast, but of course elsewhere in other towns and cities where people feel that there's increasing public disorder. If the PSNI's response is, well, we're under limited resources, and now you've told us that the begging in no circumstances, unless it gets violent, is an offence, I think that's sending out a worrying signal. But at the same time, I don't think that we should be criminalising begging per se.
Okay, that's grand. Thanks very much.
No.
Thanks, Chair.
Just on that point before I bring in Ciara, to me there's aspects to this. So there is the begging and then the rough sleeping, which is two distinct things. But visually and physically, when people enjoy the town centre or travel through the town centre, they see it visually and they see it physically, or they feel it physically. You talk about new laws, begging causing harassment, obstruction and public order offence. Would you conceive that if the problem's rough sleeping in the doorway, they're not actually begging, but yet they're causing a nuisance? Could you perceive a law where rough sleeping causing harassment, obstruction and public order? Because that sounds really bad, but it's really what you would suggest we need to do to close a gap.
Yeah. I can take that point in terms of the distinction, and it's something that the previous Conservative government in London kind of wrestled with in their reforms. From my view, I think I can understand, obviously, because the Conservative government took that view, the previous Conservative government, although the legislation obviously wasn't passed before the election, and the Labour Party's gone in a different direction. But I think in relation to if someone is sleeping in a doorway, could we say that that's harassing behaviour? It's potentially obstructive behaviour, I suppose, if they refuse to move. I notice I walk past the Grand Opera House, for example, and people sleep under the canopy there. But I think that there's probably, from what I can see, I haven't spoken to them, so I shouldn't make assumptions, but there seems to be a relationship there that those individuals know that they should move before early enough in the morning. So I don't. So in that case, it wouldn't be obstructive, for example. I just think if someone is sleeping, are they causing harassment? And assuming they're not obstructing. Obviously, if someone was to urinate or defecate, then that is there's provisions to deal with that under existing legislation. If someone was to cause criminal damage, obviously we all know that or to attempt to steal something,
it's just the offence, the second offence of trespassing with intent to commit criminal offence. I don't think that's not designed for the rough sleeper in the doorway.
It's interesting because I don't think so, but the Conservative government did put it in that part of their proposed act.
Yes.
But from I said there's so little written about it that I would and I found I put in my second report something from one of the leading texts on it, but that is from an England and Wales perspective. And if rough sleeping, I suppose, isn't a crime, if someone's trespassing with intent, it would have to be an intent to commit a crime. And if rough sleeping isn't a crime, then I don't think you can say that provision would apply. But if it was that they were going to commit criminal damage or theft or even something like urination, defecation, then I think then that provision probably would apply.
So why I asked that question is if you're going to give the police further powers to desist and move on, what is the person actually doing to grant the police the power to do that, to justify them having the power to desist and move on? And they would be simply sleeping.
Yes, if you covered rough sleeping, yes. So that's why I haven't suggested one in relation to rough sleeping, a move on direction in relation to rough sleeping, but only in relation to begging. So that's kind of why I've made the distinction, because.
And there is a distinction, there absolutely is, between someone begging and someone rough sleeping, but they could still cause the same obstruction to a doorway into a business that maybe sees their profit fall or their custom fall because of that obstruction.
So we're saying if during opening hours they were sleeping in the doorway, then I think that would certainly be potentially an obstruction issue. I wonder from the extent to which, from what I was reading, and you may well have heard from others, you might have more evidence than I do, but from what I was reading, that wasn't so much the issue that people were sleeping in doorways during the day, during opening hours, and obviously different businesses have different opening hours, and the Grand Opera House, as an example, would open later. And into the evening, and I haven't seen, when I've been to the Grand Opera House, I haven't seen people rough sleeping at 10:30, 11 when shows are finishing there. So, and if you look at, for example, London and the current approach in London, the current approach in Dublin, when Dublin repealed the same legislation as us, they created a version of the move on and desist provision in relation to troublesome begging, and they defined that, but they didn't in relation to rough sleeping, and they haven't done that either, even though they would have more rough sleepers than we would have. And in relation to in England and Wales, they have decided that they have the public space protection orders, which is something where I first got involved in this particular issue, because I was as an academic at Newcastle at the time when they were introduced. Successive governments have said that the PSPOs generally shouldn't be used for rough sleeping, but they are often used for begging. And I think I gave in my second report 2 examples. I just picked Birmingham and Peterborough, I think it was. And in what's been happening in England when they've tried to use PSPOs to cover rough sleeping is that has often been challenged in the courts, and the local authorities backed down and dropped it before the court makes it makes a decision. So I think whereas the begging provisions haven't caused that risk for local authorities.
Okay. Thank you, Kevin, for your paper. I suppose, like yourselves, and you also agree that we should repeal the vagrancy provisions on rough sleeping and begging, and it is about ensuring as well that there is a compassionate approach to those that are most vulnerable and find themselves in them vulnerable situations, but likewise trying to balance the rights of others using public spaces, and that's against distress or intimidation or harassment. So I really get that aspect of it. On the issue of the offence of arranging or facilitating begging for gain, do you have confidence in the current provisions in the 26 under the, I think it's the Criminal Justice Public Order Act 94 in conjunction with Section 3 of the Criminal Justice Public Order Act 2011, if such provisions were introduced here or replicated here? What's your thoughts on that?
I think the opinion of from looking at the DOJ consultation, they thought that in cases where someone was facilitating or organising begging, that we should rely on the human trafficking provisions. I think they mentioned that a couple of times, and you could see instances where the human trafficking legislation would be relevant, but it sets, understandably, such a high threshold, and that would be, I suppose, where someone has been trafficked into the country and then forced to beg, or where I think legislation would also apply where a child, I haven't seen examples of it in Northern Ireland, but where a child has been forced to beg. I think the trafficking legislation would apply even if they weren't trafficked into the country, because there's different thresholds. But where there's adult individuals who are part of a group and there might be elements of coercion and those adults might well be vulnerable, I think that there would be a gap there, and I suppose arguably there already is a gap because the vagrancy provision doesn't cover groups or gangs that are involved in that, and that has been the approach in London. Currently, as legislation goes through, and in Dublin as well. The two jurisdictions word their offences differently, but I think a version of that, maybe combining elements of the two, would be worthwhile, because I think it would communicate, by even if it wasn't used particularly much, I don't see what would be lost by it. It would allow us to, because at the minute people are, I think the DOJ says we have no evidence that it exists as an issue, but if we don't have an offence that covers it per se, how do we know that it doesn't exist? And I also think that communicative power of saying that if we have this offence where you take advantage of vulnerable individuals and you facilitate, organise them, pressure them into begging, that is an offence. I think that sends out the right signal that we're not encouraging people to take advantage of vulnerable individuals.
I suppose when we met with the PSNI in relation to this, they listed some of the offences which you yourself have challenged in terms of their direct applicability and reasonableness as a response to this issue, such as a disorderly behaviour one or a breach of peace. They did advocate about looking at other approaches and options in other jurisdictions that should be explored, which you have done quite clearly in your paper. Do you believe the department has done this satisfactorily, and have you attempted to engage directly with the Minister yet regarding your research into the different approaches?
So the first paper that I submitted to the committee was my original consultation response. Mm-hmm. So I suppose I did respond officially through that. I think there was 11 responses. I think it was the only academic who responded, but there was a range of homeless charities and also representatives of business groups. What I was reading through some of the responses. I can't remember whether it was to the consultation or evidence to yourselves. I think it maybe was to the consultation, but one of the responses where they had I think it may be Homeless Connect, Homeless Connect, and they had their view, which they set out very articulately, and then they also had a part where they have their user group. I can't remember the term that they use, so it's not just the professionals who work for them, the user group. And it was interesting that they articulated their user group, I think I'm assuming were people who've been homeless in the past, but I don't want to make assumptions, but assuming that they mean that. And And those individuals who'd been through the experience said there's a distinction between rough sleeping and begging. And it was interesting to hear that from them. And they said that begging shouldn't be criminalised per se, and they didn't necessarily talk about human rights, but said it was a waste of time or stigmatising. But they could see the justification for having criminal offences where that begging behaviour became particularly troublesome. So I'm not speaking on behalf of Homelessness Connect, but I just from reading their, I think it's called their user group, where makes that distinction.
Just in respect to organised crime and begging, the PSNI indicated in the rural evidence session that they believe there is suitable legislation under the organised crime infrastructure. Would you agree that that's the case?
I think not, but partly because what indicates that to me is that two governments in London have thought that and we tend to have very similar legislation, not identical, obviously, and some of our public order legislation differs partly the history of Northern Ireland, but I think that often they set particularly high thresholds, those organised criminality or the human trafficking or coercive behaviour, and I fear that if it's more passive organising, saying we'll give you a cut, but maybe it's taking advantage of someone saying you get 10% of the cut or whatever, you're only getting £20 a day. And it's not someone who's been trafficked into the country. It's not someone, cases where there's extensive coercion, or where it might be particularly difficult to get evidence of that, maybe because there's extended families involved. I think the lack of a particular offence covering that is going to be potentially problematic going forward. Even if at the minute, and I take obviously the DOJ at their word that it isn't particularly a problem that's manifesting in Northern Ireland significantly at the minute.
Just one wee final one. Just in relation to obviously your consultation research, do you believe, or is there anyone else that we should be engaging with at this stage, just in respect of the potential legislative gap that currently exists?
I thought it was particularly, it was more so with the trespass with intent. Well, because that wasn't one I said that you read my first response to the consultation, I didn't pick up on it, and it's partly because the DOJ didn't ask anyone about it. But when you look at the legislation in the Republic of Ireland when it was repealed, because it's the same legislation, they thought they needed to introduce a trespass with intent offence, and there's an interesting distinction between the way London currently is dealing with trespass with intent and Dublin did. And has more recently addressed that issue. I put a few quotes in from Labour, a Labour minister and two Labour MPs talking about the trespass with intent, and they're mostly talking about the risk to commercial businesses through trespass with intent offences, and bridging the gap between someone trespassing and someone committing theft. Whereas in the Republic of Ireland, I think it would cover that, but the Republic of Ireland is focused more with their trespass with intent on people trespassing and causing fear or intimidation. And examples you could imagine is, someone found with a spray can in an area where people are writing racist or sectarian graffiti on houses, would a trespass with intent. That doesn't need to be used in Northern Ireland at the minute, and there might be good reasons why that's not being used, the trespass with intent. But I think it would be particularly useful to hear, I guess, from the PSNI again on that issue, because I don't think that they would have realised it was an issue at the time either. And they might say, we don't use that anymore, and provide sufficient reasons to say why they don't use it anymore. But also, I guess, the Public Prosecution Service, because they were acknowledging that it was an offence a few years ago when they found the Freedom of Information request. But why has it seemed to have vanished, and why did the DOJ not pick up on it? The excellent research report, apologies I can't remember the name of the author, but it written the report for yourselves in the Assembly, and that was an excellent report, sets out Section 4, and you can see how badly worded it is when we look at it through modern legislative eyes. But it would seem that it does cover trespass with intent, but why has that why was that not consulted on? And maybe it doesn't matter that it wasn't consulted on, but I think it certainly would be worth as a committee, as well as dealing with the homelessness issues, rough sleeping and begging, to look at the trespass with intent.
Thank you.
Okay, Brian, you want to end on a wee quick one before I bring Morris in?
Well, no, I'm happy to wait
Happy to have it.
because I've already had to go. So.
Okay, Morris. You're on mute, Morris, still. Still. I don't see the wee speaker, the wee, wee microphone, so is it through this our system?
It might be.
We're to blame, Morris. You're pointing at us there.
Oh, there's it now.
Go now, try now.
Yeah, listen, thanks very much, Chair. Appreciate that. Yeah, you have me on mute. I was wondering, will there be some sort of matrix coming to the committee to have a look at to define vagrancy from homelessness? Whether it's aggressive or intimidating or obstructive, something that we could have a look at to see how the officer on the beat is going to assess whether somebody's homeless or whether they're actually begging. That's the first one. The second one is there a danger of displacing these people who are professionally begging off the main street into residential areas and to public buildings and outside public buildings? And what evidence is there that paramilitary groups or organised crime groups are actually engaging, forcing or coercing these people to beg on their behalf?
There's interesting points
Hello?
about.
Yeah, go ahead.
Thank you. I haven't read anything about paramilitary organisations being involved in this, but that doesn't necessarily mean that it's not happening. But I haven't to date. But I guess there could be something further to ask the PSNI about the in terms of the, I suppose that argument, and it's a legitimate one to say, well, if you're simply, are you just moving the problem on? So this is in relation to rough sleeping, but begging, or if there was a rough sleeping move on direction as well. So the way that and there could well be an element of that, but the way the legislation is drafted in the Republic of Ireland, and the proposed move on direction that the Conservative government had seemed to be very similar in relation to nuisance begging to the Republic of Ireland system, or even how PSBOs currently work in England and Wales. What they say that if someone, they cover a range of behaviour that is seen as, they give examples of behaviour that's seen as harassment or obstructive or intimidating. So it isn't just that what we might be used to when we hear about, causing someone alarm or distress, but they also list examples. So at an ATM machine, for example, or in front of a commercial property, that comes under under the legislation in the Republic, but also what was proposed in England and Wales and what you could find in PSPOs. There are other examples, including outside private dwellings, that are covered by that. So certainly, I think you would need to make it extensive enough to give those examples where, as you say, that it didn't just, if it didn't mention private properties, that you didn't move the problem on to private properties. But the proposed legislation, the original proposed legislation in London and the current legislation in the Republic of Ireland does cover that. So it covers begging outside of private dwellings. And that doesn't have to necessarily be harassing or causing alarm or distress, but the mere fact that it is. It probably, I imagine, doesn't happen that often, but there are properties in town centres where people live, so it I guess potentially could happen.
Hey, Morris.
Yeah, thanks very much for that.
You asked the question about the Bobby and the Beat, and what have you any, Professor Brown? Have you any?
Yeah, I think looking at the PSNI approach, what the PSNI have said is that in relation to rough sleeping, their approach is not to criminalise, but it is not to ignore the problem, but it is to coordinate with homelessness charities to signpost people, and not just signpost and say, well, you should get help, but actually bring in those organisations. I think it's different, obviously, depending on the town or city, but I think in the evenings, it's the SOS service, I think. During the day, I think the Housing Executive also has a function as well, and another charitable organisation. So it's not just signposting, but offering, bringing in other organisations to help with that. In relation to begging, I think they have a tiered approach, where and even now where there's a complete criminalisation of begging, their approach is only to get involved where it's persistent or causing harassment or distress, and then they use a tiered approach. Give a warning, ask someone to leave the area, and then move on to a community resolution notice, or eventually to prosecution, and but also having a power of arrest attached to that if necessary. I think that approach is a sensible one that the PSNI have. I would endorse that approach, but I would worry, and I think it comes through from the PSNI, I don't want to speak for them, but that they fear that just repealing the vagrancy provisions and not replacing it is creating a gap that would undermine not this draconian approach, but this proportionate and step-by-step approach.
Okay. Marshy, enough?
Thank you very much.
Yeah. Okay.
I'm happy enough with that. Thank you.
If I could just ask a few questions, Professor Brown. You very helpfully set out wording of a clause for the begging, causing, harassment, obstruction, and the public order piece. You didn't set out what a clause should look like for the offence of arranging or facilitating begging for gain. Why not?
Having a look at the legislation, obviously there's the legislation in England and Wales that's currently going through, yes, which we could use the wording from that, and it's the Labour government's wording on that is the same as the Conservative government's wording, so that was part of it that was carried through. So there's been two parties, and it seems to, I haven't heard by other parties objecting to this provision in England and Wales. When the package of reforms which includes this offence in England and Wales was announced by the Labour government, they carried in the press statements, endorsements from homelessness charities. So I haven't seen homelessness charities criticise this particular provision in England and Wales, but I could have missed it. I don't want to make assumptions. So there's that provision in the current bill in England and Wales, and then the legislation in the Republic of Ireland. It's I'm trying to find the exact provision, but there we are. It's in the Republic of Ireland. It's the Criminal Justice Public Order Act, 2011, and it's Section 5. And I would say the Republic of Ireland's approach is more. It uses different wording, so it talks about controls or directs, organises, materially involved, forces another person to beg, or otherwise causes another person to beg is guilty of an offence. The maximum prison sentence in the Republic of Ireland is very high for that offence. It's just looking at it here, it's 5 years. Arguably, I think that's too high for that, because if you're dealing with a very serious case, you would hope that the human trafficking provisions would kick in, but we're dealing with that gap in between. I think, speaking to you, if you decided that you wanted an offence in this area, I think it would be useful for your legislative draft people to say, well, in the context of this jurisdiction, the terminology from England and Wales might fit better, or the terminology from the Republic of Ireland, or a mixture of the two. The Republic of Ireland's legislation is more specific as to what's covered, so you could say that's an advantage to it. Potentially it has too high a penalty attached to it, and then the English and Welsh legislation, it could well be that that's been decided upon in a way that possibly fits with our system better. But I think having draft people looking at those two provisions, if it was decided in principle to have such an offence.
During the Department's review of this vagrancy legislation, the police didn't raise this as an issue, organised or coerced begging. They didn't see it as an issue. Do you see it as an issue? And if you do, can you put any sort of percentage terms on how organised it is within our begging community, for want of a better word?
Yeah, I think I would take the person at their word that they're not seeing as a significant issue there. I just think at a time when we're repealing our vagrancy legislation, to communicate the message, and part of why we have the criminal laws, to communicate a message to society and to public, to say, well, we have decided, unlike London and unlike Dublin, that we're not going to cover this behaviour. I think you could end up creating a significant problem, and then to say, well, we're going to wait for a review for 2 years and then decide whether we deal with this, I think would be a significant cause for concern. But I do take the person at the word that maybe there isn't a huge problem with that at the minute.
You could happen to organise basically a marketplace for organised crime.
Yes. Are we sending a message to groups in Northern Ireland, to groups in England, in GB, to groups in the Republic of Ireland?
Because we do know that from time to time we've heard stories of paramilitaries coercing young people to go out to raise money, collect money. So it wouldn't be a stretch to say that they wouldn't then start commencing begging.
Yes, that's a very good point. Yes, I think.
Because it's all raising money for that. I'm of the mind that we should be looking at repealing more law. I think that a legislature like this could be repealing law just as much as it would be making law. And I think when you read the 24 Act and the 47 Act, it's actually horrendous reading them in the context of the time.
Yes.
Straight after the Napoleonic War, when soldiers were coming home injured, or families were left without the breadwinner. And then, of course, the 47 Act, when the famine, when victims of famine and hunger, and these laws were basically created to stop that nuisance. We don't think in terms like that anymore. Soldiers actually in the Napoleonic War were they weren't adhered at all. They weren't seen as heroes. They were seen as nuisances, Tommies and the redcoats. So you can understand why the laws were put in place. But just because you repeal is probably the wrong word, modernise law should be the way the legislators would go about. Can you see a sympathy in that, where you would modernise law more often?
I think it's interesting I teach this particular subject to students in the second semester, and we look, I'm not a legal historian, but you can trace the original vagrancy provisions all the way back to the Black Death. Obviously not these ones, but the earlier ones, and often they were about preventing people from moving, the fear that could cause issues, and sometimes and gradually they've been modernised. Actually, England and Wales's version of Section 4, they brought in legislation to say that it's not rough sleeping in all circumstances is not a crime. This is legislation from about 100 years ago. I can't remember the exact year of the act offhand, but so actually our legislation goes further by having a complete ban on, as it's currently written, on rough sleeping than England and Wales, and yet England and Wales are still repealing. But I do think particularly when you look at the wording of it, and is there a trespass with intent offence in there? Is there not? And why is it stopped being used? It's because of the wording is so archaic that it's hard for us to identify what provisions are in there and what provisions are going to be lost. And when I looked at that a Freedom of Information request that someone had put into the Public Prosecution Service, they came back with a range of offences that are actually covered under Section 4. It was more just a statistical analysis, and I think the person asking for the Freedom of Information request was just interested in homelessness. But it showed you that there was a range of offences there. I think it would have been helpful for the DOJ, and it might still be, to spell out, are there any other offences that are going to be lost under Section 4, particularly because they didn't ask that question and prompt people to consider that. I said it might well come back that you say, no, there isn't, and trespass with intent we don't have to worry about for X, Y, and Z reasons. But I think that would be to go back and say what potentially might have been missed if anything.
Yeah, it talks about every person being found in or upon any dwelling house, warehouse, coach house, stable, outhouse, or in any enclosed yard, garden, or area that for an unlawful purpose. You know, so there's, when you read that, it's you know, when they talk about rogues and vagabonds, it's archaic. It's really bad.
But I think that is the clause that's in there, which is has now been interpreted in modern criminal law. At least it has in England. They have a slightly different wording, but it's trespass with intent. And the police in England and Wales had said to the current Labour government, and I think the previous Conservative government, actually you're going to mistakenly remove that when you're actually dealing with, primarily concerned with the criminalisation of or decriminalising homelessness.
Yeah, okay. Yeah, fair point. I think that's something we can chase up on in the department. Brian, you still want in?
Yes,
and then
sure.
Patsy, you want in also? But,
Yeah.
Brian.
I mean, again, your paper is very helpful, Professor Brown. What concerns me most in our papers is the paper from the Office of the Justice Minister. And I don't know if this has changed since this position, saying in repealing those two sections in the two Vagrancy Acts, we do not propose the introduction of any replacement legislation upon repeal. And saying that there are existing harassment, disorderly behaviour and public order offences available that can be used in helping the police to deal with these incidents. And I contrast with what you've advised us, England and Wales, that the old law has been repealed but not implemented. Yes. Because of insufficient replacement. In Scotland, they did repeal it. But they have additional offences that we don't have, common law offence of breach of the peace. And they also have then local authorities actually wanting to bring forward bylaws to give them the tools to address problematic behaviour, but the Scottish Government blocking those.
That's correct, yes.
You know, yeah, and your conclusion is that if we repeal the vacancy legislation, it's imperative that Northern Ireland produces a carefully considered and balanced replacement framework. So if that is still the position of the Minister, I don't think we have the actual wording, is that right, of the legislation? Do we have it? We've just the intention?
We have the amendment to repeal.
Yeah, but the actual wording that would be in...
It's very vague. It's basically just saying we will repeal the Vagrancy Act 1824 and then part one of that, and then part two they make consequential amendments relating to the repeal of the acts. Yeah. But it's basically Section 4 of the 24 Act, yeah, and Section 3 of the Vagrancy Ireland Act 1847.
Yeah, but I think a position is just saying we're going to remove those and not provide, not address what is already a lack of other measures, you know, for the authorities. I think would be harmful, and I think this needs more examination.
I think you raise a point that we haven't addressed so far. A useful point that looking at Scotland, obviously, as you correctly say, it's different legislative powers to begin with, but local authorities there have felt that they have insufficient powers to deal with the issue of intimidating or aggressive begging, even considering they have a much wider breach of the peace power than we would have. And as I said, it's the position of the current SNP government that they won't allow it. And I guess if we just pass what's proposed by the DOJ and just repeal, we're going to probably see some local authorities in Northern Ireland say that they want to introduce bylaws, and you'll know better than me, but does that go to the Department of Communities to approve them? So
ultimately, you have to go through the executive at some level. Yeah.
Is that right? Okay, you have to go through the executive.
Well, it could be blocked there.
Okay, yeah. I didn't realise that. So yeah, so I think then what you're going to see is that also that piecemeal, where assuming it's not blocked, but then I'd also be worrying that if it's just blocking, if local authorities saying there's a real problem here, and we haven't legislated nationally to deal with it, across Northern Ireland to deal with it, and we're not going to let local authorities. Or if we do let local authorities, some people might complain and say, well, this power's gone too far in whichever local authority, and whereas in this local authority it's not being criminalised at all. So I think there's certainly risks, and then the enforcement of bylaws is quite tricky. As we know, compared to criminal laws. So yeah, I'd be worried that not doing anything also certainly leads to some local authorities saying we need bylaws to do with this. And that's been an issue with public drinking, that we don't have enacted legislation. I know it's proposed by the DOJ that we would, but next mandate, introduce new legislation on that. But the councils feel that bylaws aren't necessarily effective enough.
Okay, Patsy, you want to in again?
Thanks very much, Chair, and thank you. You've kind of set me thinking here on the trespass issue. I'm looking at it, I'm thinking of a range of issues where it could be the answer, static answer from police could be that's a civil matter or whatever. But you rightly touched upon someone with a spray can going into a housing estate, a private housing estate or whatever. Doesn't really matter. Where there's a litany of racist or sectarian graffiti sprayed, right through to someone who's caught with the gear breaking into a property. Well, no breaking and entry can be taken in there, or about to break into that property. Or it could be harassment of an individual, or it could be an issue of people with a spade and dogs about to go badger baiting on private property. I'm just thinking all those issues that cover trespass, in order to contemporize it, would you suggest that there should be one descriptor which says it makes an offence to trespass with intent to commit a criminal offence, or trespass with intent to commit a criminal offence, and list what potentially those offences could be?
It's a good question. The approach of the current government in London is just to say trespass with intent and not specify the offences. In Dublin, it's, I guess, a mixture of the two. There is a more, we just get the exact wording. There is a more general trespass with intent. I think it's the Criminal Justice Public Order Act 1994. It shall be an offence for a person to enter any building or the curtilage of any building or any such part of a building as a trespasser in circumstances giving rise to the reasonable inference that such entry or presence was with intent to commit an offence. So that's the more general one in the Republic.
That one there just refers to a building, not property.
Or to be within the vicinity. Sorry, I didn't read part B.
Right, oh, sorry.
Okay, but you're right. That's it's an important point. And then the Republic of Ireland also then has, when it introduced its hate crime legislation, and I know we're coming to hate crime legislation in the sentencing bill, the Republic of Ireland then created a version of that which is intent to commit an offence aggravated by hatred. So that was the points that you, example where it's racist or sectarian graffiti, for example, there was intention, and then they also have one where, and I'm trying to get the exact wording of it, but yes, this is a specific one which they don't have in England and Wales, but this is in the Republic. It shall be an offence for a person without reasonable excuse to trespass in any building, etc., in such a manner as to cause or is likely to cause fear in another person. Right. And so which it's an interesting as to why
that's
they.
Is that Republic?
That's the Republic. Yeah, that's not in England and Wales. And there can be the Garda can ask the person to move on in those circumstances, and I'm guessing that might be used in similar ones where there might be harassment that's taking place.
Yes.
Of individuals or even you can imagine politicians, for example, something like that. But yeah, that and I guess fear isn't necessarily a crime, so I guess that's maybe why they've distinguished and had a separate one on that.
Or to interpret that one person's fear is another person's so what?
Yes, it's quite a widely written one. Yeah, so I don't know how often that one is used, and was it necessary when you had the general one that they have in the Republic, and then you do have it aggravated by hatred if necessary. Yeah. So it's I must admit I don't know how often that's used and in what circumstances the guards might be using it.
Just in your opinion, would it be better just to have one which is specific, which says trespass with intent to commit a criminal act, full stop, or trespass with intent to commit a criminal act, and then have not examples of them, but a specific list of what those acts may be?
I think a more general with intent, because we do have we do have specific examples of criminal trespass with intent under specific legislation. So in relation to someone trespassing with intent to commit a sexual offence is already covered. We have trespassing with intent to commit theft, I think GBH, and criminal damage is under the burglary provisions. You don't actually have to burn, but
trespass.
yeah, there's other ones which may be influenced maybe by the history of Northern Ireland, but there's ones about in terms of public buildings, trespassing in public buildings, and which would include here or where I work. It's quite a wide interpretation of public buildings. So our legislation has specific examples of trespass with intent, but there isn't a general one. Now, as I said, I don't know the extent to which what's currently under Section 4 is being used by the PSNI or not. I couldn't find information or much discussion of it. But I think it would certainly be worth, if the committee was thinking that might be something that would be useful to have, asking the PSNI and the Public Prosecution Service, is that offence still there? It would seem to be. Why is it not being used if it's not being used, or when is it being used? And would a modern replacement be something that they would value?
Okay, thank you. That's very helpful.
All right.
Okay, thank you. Nobody else wants to come in on this, so just remains for me then to thank you, Professor Brown, for your time here and your input and your very detailed consultation responses that you've kindly shared with us and added to. So thank you very much. It's been very, very worthwhile.
Thank you. Take care, everyone.
Okay, all the best. Thank you. Okay, members, just before we move on to the next agenda, there's some aspects there people wanted to chase up on. Is there anything? I think we need to ask the question. I think we need to ask the question of the department: are you sure that when you repeal this, that you're not losing other offences that have been there, tied up in the wording of the 1824 Act, but then could drop off the statute book? And the one specific was the offence of trespassing with intent. Is that right? Am I right in saying that? Yeah, what about the offence of trespassing with intent to commit criminal offence? So is there an issue there that could drop off a law, drop off a statute book just by the fact that you've appealed the law, you've repealed the law to try and decriminalise begging and rough sleeping? I think we need to ask that of the department. Is there anybody else want to add anything else then to that?
Yeah, I mean, I don't know, is it in order for us to write to the Chief Constable or write to the police asking their view on the powers that they feel? I just feel like we're behind, and I think everyone gets the idea that rough sleeping or begging, it's not prosecuted in every case. So there's a bit of appropriate enforcement, adopted, but removing it and not having the sufficient powers in place. I think that's the message we're getting. It's going to leave a significant gap, and even the public message, of saying it's no longer legal to rough sleep or to beg in the streets. So whether we can ask the Chief Constable for his view.
We could write to the Chief Constable of Police, but we should all, I think, write to the department and say, look, what do you think of this wording for an amendment? The one that he has outlined, Professor Brown has outlined there, with regards to begging causing harassment, obstruction or public order, and then also ask them about the offence of arranging or facilitating begging for gain. That echoes very similarly to the human trafficking stuff with regards to the decriminalisation of prostitution. So you're criminalising the offences towards the pimp, not the prostitute. So in many ways that's similar to that, where you're not criminalising the beggar, you're criminalising the person who's coercing that person to beg. I think these are valid questions that we should be putting to the department. Members content? Any other questions or requests from the department? Kathy, do you want to
Sure, yeah, I just wanted to draw members' attention. The committee did write, following the earlier evidence session with PSNI and did ask about potential gaps. So the PSNI did come back to say existing legislation will not always be a good fit. For example, the use of some public order legislation requires a person to be caused alarm, harassment or distress, and often there will be situations where this test is not met. I can forward you the links to the PSNI's correspondence on the specifically about vagrancy.
They've already replied, basically.
They have, and there's another one. Then the committee then subsequently went back to ask how many times people have been prosecuted, and across. I think there was geographic questions as well, so I'll forward you the link to that as well. Plus the PSNI will be back in again.
And Chair, can I ask, did we get response from business groups, you know, especially like the likes of Belfast City Centre, Belfast One, Belfast City Centre Management?
Maybe I'll answer that. That's in transit at the minute. Yes, we've got the Complex Live team have come back and said that they don't feel like they're in a position to give us evidence, but Retail and I have responded, and we're trying to organise that, and we're waiting on a couple of other ones coming back. So yeah, hopefully.
We're the intention is to organise maybe a panel with a few different business organisations represented, and similarly a panel with homeless organisations maybe represented to try and cover different aspects.
Thank you.
Okay, happy enough. Members,
No, I was just saying that we were obviously before you came on the
I'm-
committee,
I'm-
we were
I'm
keen
learning,
to get.
catching up with where the committee's
No,
at.
there's a lot of it even for us, and we've been here, but we are keen to get the PSNI back maybe once or twice again potentially, because you would need to break some of this down and take it in chunks, because biometrics in it of itself would take a full meeting, and then obviously to come back to any of these queries, it might be useful just to hold any potential questions to the side, just to remind us then again when they are in front of us.
okay,
And even to give them some of the kind of questions or areas that we
Right.
want covered in advance, so that
yeah, sure.
they have the right people here and they come prepped. Yeah.
Okay, thank you, Deirdre. Right, are we happy to move on then? Content to move on? Agenda item number 5 then, Justice Bill, Fingerprint and DNA Review Mechanism. The Department of Justice written paper. I refer members to pages 54 to 85 of the meeting pack, which contains a paper from the Department of Justice on a proposed review mechanism in relation to the DNA and fingerprints retention framework. Can I remind members that the committee is currently considering the new DNA and fingerprints retention framework for Northern Ireland contained in Part 1 of the Justice Bill Biometrics, which Deirdre has just alluded to, which includes the introduction of a statutory review mechanism to assess the continuing need to retain long-term DNA profiles and fingerprints. Can I inform members that the Department has advised that the review mechanism will be brought forward following public consultation by secondary legislation once the Justice Bill has received royal assent, to allow flexibility to amend arrangements if required to meet future requirements. Can I inform members that the Department has now developed proposals for a suitable review model that it states will comply with data protection regulation and will be as efficient as possible operationally for the PSNI. The proposed review model has been developed through engagement with the Northern Ireland Human Rights Commission, the Northern Ireland Commissioner for Children and Young People and the Information Commissioner, as well as the PSNI and the Departmental Solicitor's Office. The PSNI have confirmed that they are content with the proposals. Can I inform members then that the review mechanism proposals contained within the Department's paper include the setting of a statutory review date part way through the statutory retention period, as well as approaches to operational matters such as how an individual can submit a request to the PSNI for a review of the retention of their material at any stage, how an individual can submit a request for a reconsideration of an initial decision made by the PSNI to retain their material, details of the statutory review dates and how the process will operate, how an individual can complain to the Northern Ireland Biometrics Commissioner, who can make a request for a review, e.g. the process for under 18s applying, and then lastly the process for requesting a review where an individual has deceased. Deirdre, you want to come in on this?
Yeah, no, I just have a couple of questions, Chair, to go back to the department. So it was a useful paper, but it obviously presents a number of areas for further scrutiny. So the first one, as you say, the PSNI responded, but I would be keen to hear the response from the Human Rights Commission, the ICO and the Commissioner for Children. Were they content with the review proposals? And if not, or if they are, that's good, but if they're not, what areas of concern would they have? Onto the proposals as well, obviously it also said a review would be considered and somebody would be designated by the Chief Constable, and then obviously a reconsideration that an individual would be again designated by the Chief Constable, and that just seems to me like the police are marking their own homework around some of this, and obviously raises questions around the independence of somebody who retains the material also being the decision maker of that material being deleted or not. And this was actually raised by the departmental solicitor. So I think it does raise serious concerns. The Law Society previously in their evidence also proposed that individuals should be able to apply to the Magistrates Court requesting a review. So again, I don't think what the department is putting forward addresses, I suppose, any of their concerns. So it would just be to see what DOJ anticipates in terms of these regulations, and also how they address the concerns of their own departmental solicitor in terms of that. The other area then I'm concerned about is where they're saying that the review mechanism will only apply to the 75, 50 and 25. So in terms of any retention 10 years or less, and particularly around under 18s in that 5-year period. And I suppose one of our big concerns around the biometric stuff is the impact on children and young people particularly. So I would have a concern around that aspect of the review mechanism, not including those elements. So again, I suppose the thing is around again the oversight of the Chief Constable in the process and the kind of accountability. And I suppose it would be who apart from the Chief Constable will have oversight of the process to ensure that there is accountability and certainty that it is being done in a proportionate and lawful manner. So again, I would just like to know around what is the role of the Commissioner going to be, because obviously we don't get any of this until afterwards. So I would be keen to hear their views on that. The other bit then around also, I suppose, the concern where they said that people will be notified, they'll upload information onto the PSNI website that you can request a review. But for those that aren't IT savvy, I would be keen to know, can that not be done through their legal advisors or through other routes as well, rather than just saying it's on the PSNI website? I mean, I even struggle to navigate the PSNI's website, let alone Joe Public. So I'm just keen to see if there is a way that can be done via the website. And sorry, I've just one more area. So just in terms of conclusion of the PSNI's process, where an individual still remains dissatisfied, I suppose, with a continued retention, there's then a complaint to the Biometrics Commissioner, who will determine the lawfulness of the retention and the procedural fairness. So it seems like that their oversight of their decision is only around process, rather than can they not overturn a decision. So again, it goes to the heart of what is the role of the Commissioner themselves. And if he considers, or she, the retention unlawful, can they direct the PSNI to change their decision? So I suppose for me, two key aspects around it's the PSNI and these proposals marking their own homework. And there may be an initial phase where the PSNI will review a request. But if the person is dissatisfied, then it's what else they can go to. And then I suppose it's trying to understand more the role of the Commissioner. So if the PSNI reconsider the decision but decide further retention's necessary, would the Commissioner have the power to overturn that decision?
So it's the role and power of the Commission.
Exactly, yeah. So just a couple of queries I would like to know around those areas.
Fair enough. Okay, any other member want to
Sorry,
add?
Kathy, I hope you get all that.
Writer's cramp.
Back in, I do. Can I just, sorry, double check,
Go on
sorry,
ahead.
Chair, if you
Yeah,
don't
yeah.
mind. Deirdre, you said you'd be keen to hear the response from NIHRC, Nikki and the Information Commissioner
Aye.
directly from them. Do you want to strike directly to them on this?
It's just the paper said the PSNI were content, but they don't give you any information on the other three.
Okay.
So I'm keen to just know what
From the department?
they've
Okay.
said. Yeah.
Thank you.
At this point. Or if they have the responses, it would be useful to see them.
Yep. Okay, fair enough.
Thank you, Chair.
Members content to move on. Then just remind members that there will be sessions with the department at the end of this also, along with the PSNI. And again, like Deirdre, I think that for the department themselves, this is going to have to be a, it could need more than one meeting, and it might need to be broken down into sections of the bill. As Deirdre says, the biometrics piece is a big one at the start. Okay, agenda item number 6. Then Justice Bill written papers, 6.1 Justice Bill, request for further information table. Can I refer members to pages 87 to 121 of the meeting pack, which contains the documents prepared by the committee team to track committee requests and responses received in respect of the Justice Bill and the proposed amendments. Can I seek members' agreement to note the list of requests and responses? Again, this is a rolling feast. Agreed. 6.2 then, Belfast City Council Complex Lives. Refer members to page 7 to 14 of the table pack for relevant papers. Can I remind members that the committee agreed at the strategic planning meeting to approach the Complex Lives team of Belfast City Council to ask if they or their constituent organisations would wish to give oral evidence or written evidence to the Vagrancy amendment. The Complex Lives team has confirmed that it is not in a position to provide evidence, but has provided a briefing on Complex Lives for information. They have also forwarded the committee's request to partner organisations and asked if they are content, to ask that they contact the committee directly if they wish to respond. Can I inform members then that the committee team has also contacted homeless organisations and business organisations directly. It is hoped that if any of these representatives are content to give evidence, these sessions can be scheduled in November, and that's basically what the Assistant Clerk had stated earlier on. Members content to move on. Agenda item number 7, renewal of the Secretary of State's direction under section 1A7 of the Prisons Act Northern Ireland 1953 as amended by Schedule 4 of the Northern Ireland Act 1998, Devolution of Policing and Justice Functions, Order 2010. Can I refer members to page 122 to 134 of the meeting pack for the relevant papers? Can I remind members that at its meeting on the 2nd of October 2025, the committee considered the paper from the Department of Justice outlining and seeking the committee's view on the renewal of Secretary of State's direction under section 1A7 and 8 of the Prison Act Northern Ireland 1953. Can I remind members that the direction sets out arrangements for how the Department of Justice officials, when dealing with operational prison matters which remain in the reserved field, are to be treated as officers of the Secretary of State, subject to his direction and control, and how they handle protected information, particularly in matters of national security. Can I remind members then that the direction is renewed on an annual basis, and the Minister is of the view that it remains fit for purpose, but sought the committee's view ahead of the renewal of the direction next month. As part of its consideration of the Department's paper on the 2nd of October, members agreed to ask the Department of Justice for more detail on what operational prison matters referred to in the papers involves, how many prison officers currently fall under the remit of this direction, and for more information on who prison officers who are operating within this direction are ultimately accountable to. Can I inform members that in its response the Department has advised that it is a very small number of prison-related functions that can be exercised under the direction. The number of staff involved is minimal and no staff work exclusively on these matters, and they remain accountable to the regular line management structure. The Department has also advised that the Prisoner Ombudsman, when investigating decisions that touch on national security related issues, will be bound for that purpose by Secretary of State guidance. Can I seek members' views on this, or whether they are content at this stage? Deirdre?
It was just, just to thank the department for the update. It was useful, but just on that last bit in terms of the role of the Prisoner Ombudsman and that issue around being bound by guidance, I'd just be keen to see what the guidance is. So just information around that, please.
Yep. Okay, so we'll seek that further question with no time scale or pressure with regards to giving the committee's view on this.
No, Chair, I think it's towards the end of November that it has to be reviewed.
So we can seek that further clarification then before we would ever put the question to the committee? Members, Gary?
It's obviously still quite vague round numbers and stuff, just for me to
Yeah,
get my
it's
head
a small
around
number,
the
yeah.
actual level, volume, whatever. It would be really, really useful, just to get it set in context. If we could get numbers.
So you want specific numbers?
Yeah.
Because they do talk about small numbers, don't they?
Yeah.
Small, minimal numbers?
All mean,
Yeah,
because we don't know
minimal.
what it's in comparative to, so.
Yeah. Okay, we can go back to them on that. Members content then to move on at this stage? Agenda item number 8 then is the Youth Justice Agency Performance Impact Report 2024 to 25. Can I refer members to pages 136 to 155 of the meeting pack, which contains a copy of the Youth Justice Agency Performance Impact Report covering the 2024-25 year. Can I inform members that the report uses a mixture of quantitative data, user feedback and case studies to provide a picture of the agency's work and its impact on children, families, victims and communities. Can I ask members if they are content to note the report or if there are any other information or clarification is required at this stage?
This is just one wee point, and obviously we've had youth justice in, and we have to obviously give praise to the current work that they are doing and the excellent results that they are receiving with young people. But it's just that one statistic in relation to, I suppose, the young people getting access to education, training and employment package at discharge. It was lower than everything else, it's quite low. I would be really useful to find out what is the difficulties in being able to get those placements. And what actions are they taking maybe to be able to increase and have a more successful outcome for these young people when it comes into receiving a placement.
Okay, members content with that? Cathy, you happy enough with that request? Okay, agenda item number 9 is correspondence. Can I inform members that there is a correspondence memo and 8 items of correspondence at page 158 to 209 of the meeting pack. Can I advise members that I will draw their attention to one of the items and they will then have the opportunity to comment on any other items of correspondence in which they have a particular interest on. Item 9.9. Can I refer members to page 209 of the meeting pack, which is an invitation from Northern Ireland Alternatives and the Community Restorative Justice Ireland to a celebration of restorative justice and practice event on the 21st of November 2025. So can I advise members that if they wish to attend, they should RSVP directly via the details in the invitation. Item 9.10. Can I refer members to pages 16 to 96 of the table pack for relevant papers? Can I advise members that the SIGINI has laid a report on an inspection of the Police Service of Northern Ireland's use of community resolution notices. It's very timely considering the committee meeting last week. The report makes 3 strategic recommendations and 2 operational recommendations. Can I remind members that the committee agreed last week to write to the PSNI on a number of issues regarding the CRNs. Can I seek members' views on asking the PSNI, the Public Prosecution Service and the Department of Justice for the responses to the findings and recommendations in the SIGINI report? Anyone want to comment on it, or are you happy enough to move on? Can I ask members whether they are content to note the other items of correspondence as set out in the memo, or whether they have any comments to make? Doug?
Just one, Chair. 9.3, we asked that question about the annual domestic abuse training statement because we were unhappy about the Northern Ireland Courts and Tribunal Service. I'm looking at the response here, which is fine. I'm not trying to get blood out of a stone, but it's totally inadequate. And I think we need to put a marker down. At least we're not going to get anything this year, but if we put a marker down that we expect better for next year, that we do expect figures, because what they've basically done is that they just haven't kept the record. And it might sound like a minor point, but to me it's really important, especially the Northern Ireland Courts and Tribunal Service.
Okay, yeah. Details keen?
Yeah.
Okay, thank you, Doug, for that. Okay, any further comments from any of the members, even on screen? As it goes off on us. Agenda item number 10 then, forward work programme. Can I advise members that the draft committee forward work programme is at pages 211 to 216 of the meeting pack? Can I advise members that since this week's meeting pack was issued, the Examiner of Statutory Rules has reported on the 3 statutory rules that members will see were provisionally scheduled for consideration on the 13th of November in the forward work programme. The committee will therefore now consider these SRs at the meeting of the 6th of November 2025, so we'll bring that forward a week. Can I remind members that at the strategic planning meeting session, members advised that they would wish to further consider the advice from the Examiner of Statutory Rules on the delegated powers in the Justice Bill and the proposed departmental amendments. The Senior Assistant Clerk has prepared a paper providing an update on this, which will be provided to the committee at the next meeting on the 6th of November. Given that it draws on legal advice from the Examiner, it is proposed that the meeting on the 6th of November begins in closed session to allow members to raise any issues that they may have, because it's the legal advice side of things. Are members content that we start that meeting in closed session?
Right.
Okay, can I seek then members' agreement to the forward work programme as it is, subject to the changes we've just agreed today?
Great, Chair.
Okay. Agenda item number 11 is Chairperson's business, of which I have none. Agenda item number 12, any other business? Yeah, sure. Just any other business. Patsy had contacted me yesterday just about the concerns around the media story was run yesterday about alleged sexual assault in one of our prisons. So I had spoken to Cathy the clerk here just to see if we could get some sort of information from the department on that. There was an email sent out just before the committee meeting, just making you aware of that. There are copies here too if you wish to have one. But just we acted on that. Patsy had, as a member of this committee, had contacted me with concerns. I would then contacted the clerk, and we proceeded just to find out information before our meeting. Now it's scant, but again it's probably for 2 aspects. One, the speed of which we've requested this, and then obviously the actual nature of the activity and the fact that there is a police investigation ongoing. And that's the reason why it would be scant. Patsy, you want to come in?
Thanks very much for doing that, Chair. It is pretty scant, and I understand police investigation ongoing. There's only one question that I have. Was the alleged victim an inmate or not? And was the alleged perpetrator an inmate or not? Well, that's 2 questions. But
okay, connect it. Yeah. Okay, we can ask that question. Yeah.
If I can, Chair, and I think that's a fair question. Actually, I think the simple is to find out whether or not, if it's inmate on inmate, whether it's inmate on staff, whether it's staff on inmate. I think that's what we need to. And what might be useful as well, Chair, I'm not sure whether they would give this as which prison, unless it did say.
Gilligan, was it?
Because that might give us an understanding of the age bracket we're talking here. So that might be useful to know.
It was versed in the media. I didn't see any of the coverage.
No, I didn't.
Honestly,
either.
I didn't see any of the coverage, so I just don't know. But it was Patsy who had brought it to my attention, and then we had acted on that concern.
First I've heard of it.
Yeah.
Just my understanding of how it ended up in the media. I mean, are the prison service obliged to? Was it leaked by somebody, or are they obliged to let it be known that there is an alleged offence has taken place? Or
I'm not sure, to be honest with you. Go on ahead.
Can I just raise? I mean, this is another point, and you'll remember this when you were the chair previously. We used to get information about adverse incidents briefed to us. Protected information. Look, this has happened, and we used to get that, so we were never caught off guard, particularly on deaths. If there was a death in custody, we were always told that was. We didn't do nothing, but we knew about it, so we weren't caught off guard. This would be one of those instances where I think it's right that the committee is told we have a serious adverse incident ongoing. You need to be aware of this. Not to go to the media, but at least we know of it because somebody's been to the media.
Yeah.
And I'm literally as a committee member, Chair, not your fault, nobody's fault here, just hearing this today with this.
Yeah, all valid
Probably
points.
If we hadn't pursued it, we wouldn't have got it.
Exactly.
Oh, aye.
That's the other thing. And it was referred to in the media, rightly or wrongly, as a serious sexual assault.
Yeah.
So,
Yeah, and the questions that you pose as to perpetrator, victim, alleged perpetrator, alleged victim,
this is a
has
question.
different consequences depending on the status. So I think we're right to raise it. I think we're right to show concern. So my issue is, of course, a ongoing live investigation, which we'll have to be obviously very careful around that. But this committee here is to scrutinise the department and all of the arm's length bodies, of which prison service is one of them. Members content then?
Yeah,
Okay. Thank you, members. Agenda item number 13 then is date, time and place of next meeting. Can I advise members that due to Halloween recess, the next meeting will take place on Thursday the 6th of November 2025 at 2 p.m. in room 30 Parliament Buildings, and I adjourn the meeting. Thank you, members.